You can wave back. Hello, everybody. I'm Gary Carnegie, and good morning, and thank you so much for coming today. Happy Friday, and I'm part of the employment law group here at Primmer, and you're kind of here on the cusp of the weekend, right? It's Friday. You're looking forward to that weekend. And the only thing between you and that weekend is your decision to listen to 6 or 7 attorneys talk for 2 hours about legal stuff. So I'll leave you with that decision. I think actually it's going to be a lot of fun. We're going to talk about a variety of issues. We got a number of very smart attorneys here. We may not hit on everything you're interested in, but I'm hoping that we'll touch on that one issue that you're grappling with in HR that's a big problem, and then you can go into the weekend and you're not going to worry about it all weekend, because that's really a good part of what we do is try to lessen your worries in the employment context. Bathrooms are outside down the 2 hallways, depending on your preference. This is being recorded. And then questions on chat, folks. If you have questions, send them in. We're going to save them for the end as best we can so we can get through all the materials. So with that, I want to start and just tell you a little bit about the firm. That's our employment law team. They're also, I think we've got 45 attorneys or something, and we're in both states, in New Hampshire, Vermont. We also have an office in DC. And let's forward that. These are the folks here today: myself, Angelina, Jeremy, John, Madison, and Ryan, who are going to be presenting on various issues. And the firm has been around for a long time. We've got offices, several in Vermont, several in New Hampshire, and the one in DC I mentioned. We think we're a pretty good law firm. We have particular experience in the employment group. There's a legal disclaimer, so anything I say can't be used against me in a court of law today. And I'm going to be talking about hiring and recruitment. But first, I just wanted to add some context about employment law. I've been doing this for over 30 years. We advise clients in both Vermont and New Hampshire. When I started, President George Herbert Walker Bush had just passed the Americans with Disabilities Act. That was a big deal in my world. We were all giving seminars on the ADA and trying to tell clients what the ADA meant going forward. And like most laws, you don't know. It's going to depend on how the court interprets the statutes, how the federal government and the states apply their own laws. And then you fast forward 30 years. And here we are. And now we know a lot about the Americans with Disabilities Act. We know a lot about how courts have interpreted that law. We know how federal regulators, state regulators will look at that law and what disability means and how we deal with those things. But as you know, in the trenches, there's still a lot of questions. There's still a lot of uncertainty. That's a law that's been out there for 30 years. So our job as your attorneys is to assess how a law like the Americans with Disabilities Act and other discrimination laws might be applied to the troublesome situation that you have. So our job, as I said, is about lessening your risk. We'll be speaking for a couple of hours today. And by next week, you'll have forgotten everything we said, except I want you to remember one thing, just one thing, and that's the 20-minute phone call. So one 20-minute phone call to your employment lawyer before you take an adverse employment action, before you make that decision, or your managers do. Although that's not a cheap phone call, you'll save a fortune. And I've lived this. You'll save a fortune in money and headache down the road. Most of your companies that you work for, you have employment practices insurance, which is great. But I find clients get into the sort of the mind frame of, well, that's why we have insurance. So we don't need to really worry about this stuff. But there's a fiscal reality there that you want to consider in your HR departments. And that is this: even if the claim is meritless, if they file a lawsuit, they go to the EEOC or the Attorney General's office here in Vermont, there's probably enough in that claim that we can't just get rid of it immediately. And it's going to drag on, and you're going to spend the company's $10,000 or $20,000 deductible until the insurance monies take over. So that claim could impact your premium rates for the following year when you're seeking coverage from a carrier. So if I'm the CEO of your company, I'm going to pay you, the VP of Human Resources or the Director of Human Resources, whatever your title is, a very nice bonus at year end if you save the company from hemorrhaging that 20 grand by making the phone call or making a good determination yourself to avoid the risk. We, along with providing employment advice to clients, we also defend the cases in state and federal court. We work for most of the insurance carriers who provide employment coverage. That would be on discrimination, FMLA, you name it, anything employment, we defend. Most of you have probably been through that litigation process, but let me take a moment to describe the process. And that's why this seminar, I think, is so important. And compare this process to that 20-minute phone call. So first you're served with a lawsuit in state or federal court or an EEOC investigative document. Then the lawyers get involved and we want to interview you. We want to interview every manager and everybody who's a fact witness to get knowledge. And then we prepare and work up this document. We spend time with you, the HR professional, parsing all the words that we're going to say to the regulator or in court to answer a complaint. You spend a ton of time with us. You spend a ton of time with your IT department because we want to see all the electronic communications. You got to work with them, gather emails, get us electronic documents. Then court case proceeds and we have to do all these written questions and document requests. You will spend, I guarantee it, hours and hours looking for stuff, getting your managers to focus on this. This is a back burner issue for them. Scheduling, dealing with us. Then all your people are deposed. You're probably deposed as the HR professional. That takes a lot of time. We get you prepared for that. Your deposition, we go 3 or 4 hours. We had a case once where the VP of HR at a hospital was deposed for 8 hours. It was not fun. It was not fun. And that was on I think the legal term is crappy case. It just didn't have much merit, but we had to deal with it. After that, then there's a mediation. Hopefully it settles. If it doesn't settle, then we go to trial. So think about your busy work week, and I do appreciate you coming today. But you've got a 50-hour work week where you're developing an equity and inclusion initiative. You're onboarding 3 new employees. You're dealing with new voucher regs on the shop floor if you have one. Your CEO has these great ideas that they want to meet with you on right away. That 50-hour week now becomes a 60-hour week because every morning when you get in, there's 4 emails from Jeremy saying, how are you doing on getting me those documents that we need to review or setting up that manager? As I said before, it's a rare case that goes away quickly. Sometimes you can do a quick payment, get rid of it, but not always. 2 to 3 years that case will last 2 to 3 years. Depends on the court, depends on how it works. Most will get resolved earlier on or at the time of that mediation. But think of me taking 10 hours a week, not every week, but here or there for 2 to 3 years where you're trying to get your job done. You don't want to spend all that time with a lawyer. Trust me. We're not fun people. Not at all.
We are.
Well,
We are.
so 10% of your time dealing with litigation is time you could be using to improve your company. So going back to the original premise, 20-minute call to a lawyer costs some money, but think of the alternative. So everything you do in the hiring process, in preparing employee manuals, discipline and discharge, can reduce that risk. Reducing risk is good for your company. It makes it a better, happier place to work, hopefully, and it makes the company more profitable. So I'm going to turn now to my subject matter, which is hiring and recruitment. First slide. Okay, I'm going to touch on, my whole presentation is about 20 minutes, so this will be pretty brief and higher level. Drafting accurate job descriptions. I'm going to talk about job applications, getting the data you need, interview tips, proper ways to conduct background checks, screening references through a filter of reality, and then job offers or rejection letters. So let's start with job descriptions. And I want to spend the most time on this because I think it's the most important tool that you have as HR professionals. Why bother? Why have a job description? Well, you've got protected classes out there, you've got adverse employment actions, and what I need is a lightsaber at an employment trial. I need to point to something and say, no, we didn't terminate you because you're a woman or you're in a protected class. And I also just broke my golden rule. I told all these guys, don't say terminated, never say terminated. It's a separation, or as, what does Gwyneth call it? A conscious uncoupling, right? But don't say termination, because that sounds like Arnold Schwarzenegger. But when we get to that point, we want to be able to point to something, because ultimately, you let somebody go and they say, no. You told me I was going to do A, B, C in this job, but then you had me doing D, E, F, and you're firing me for D, E, F. That's not fair. Well, guess what? Look at my exhibit A. It's a job description, and it lays out exactly what the essential functions of the job are. It's the best tool you have to manage employees to deficient performance, to point back to it. It should be used throughout the employment relationship. Who should draft it? So think of your managers. They know what that job is. We want the essential functions set out. They should work with HR, but that job description shouldn't have anything in it that isn't essential, but it should have everything in it that's essential. And the job description then, once they put down the parameters, then you look at it and you think, okay, what do I really need in there from an HR perspective? I don't like the way they worded it. It's a collaborative effort. Level of detail, the more detail, the better. But again, if it's not an essential function of the job, don't put it in there, because it dilutes the power of the job description. Essential functions of the job, I talked about. You hear that a lot. You've heard that a lot in Americans with Disabilities Act cases. It's in the statute, but it really permeates all discrimination law. The notion of, why are they doing this? Because you're not doing the job. Well, what is the job? Look at these essential functions on this job description that we handed you, and it's exhibit A, right? Physical requirements. So this is ADA stuff, but basically when you think about a requirement, it isn't, can you, what's this called, an owl?
Yes.
Can you lift a 50-pound owl and put it over there? That's not the right question. The question is, an essential function of the job is getting the owl over onto that table. How are you going to do it, right? So it's good to have physical requirements, particularly in a physical kind of job, but keep in mind that it's not just, can you lift something? It's how are you going to get it from A to B. Attendance. This is a huge issue. I think you deal with it all the time, but it's a huge issue in litigation. Because it's never black and white. So you've got some employee, their attendance is terrible. They have some work performance deficiencies, but they also are on FMLA, or you have other legal issues to deal with. Attendance in the job description helps me defend your claim. Typically, attendance is put in your manual. You say punctuality is important and stuff. That's terrific, but I want the belt and the suspenders. So having that in your job description is really helpful to us. Also, and Jeremy will talk more about it later, if it's essential function of the job for you to be in the office and not working remotely, put that into your job description. But there will be different jobs, and depending on what your policies are around remote, which Jeremy will talk about, don't overstate it. Some jobs really do require being boots on the ground in the office every day. Others don't. So a couple of examples of how I've seen this play out in job descriptions. So here it is. So I had a case once where an employee, how I talked about the ABC and the DEF. So we have an employee who comes in and they're actually in HR things, and small companies. So as many of you know, if you're in HR in a smaller company, you got to do everything. You got to do everything. you know, A, B, C, D, E, F, G, and so on. But here, the employee came in and they claimed that they were given job responsibilities, D, E, F, but that's not what they were told when they were hired, because everybody knows they can only do A, B, C. And so I get involved with litigating the matter, and, you know, no fault of the client, but we didn't have a good job description. So then it just becomes a he said, she said. What did they say in those interviews? And they can just deny it. And if they deny it, then there's an issue, what we call an issue of fact. So it's not a case I can get rid of easily. They can go to a jury on. But if you got the documentation, it really helps. The other big example, which Jeremy will talk about, is the remote work and having that in the job description if it's a part of it. I think that's a huge issue for all of you. Think of the employment relationship kind of like dating. And these early on things that I'm talking about, I think we can close that door now. That I'm talking about are really the most opportune time to avoid litigation. So, like I haven't dated in 40 years, but as I understand it, a good way of having an initial date is you just go to Starbucks for 30 minutes, have coffee. If it doesn't work out, great, you'll walk away, right? If you are dating for 3 months, it's a little harder to extract yourself from the relationship. And then if you get married and have joint assets, then you got a real problem. So doing early on when red flags become apparent, that's when you want to, if you can, you know, check in with your lawyer, but end the relationship as best you can. Job applications. Okay, so, you know, this has changed a lot with like Indeed and the internet. But I guess the simple message to you is limit it to what you need to make the hiring decision. And again, job descriptions. I like the job description be attached to the application. So when they fill out the application, it should be aligning with what the job is. Notice of truthfulness. What that means is you should have on your application something to the effect of, please be truthful on this application. If you're not, it would be grounds for termination with a, you know, so that's helpful because you have cases where you find out later they lied on their application, and then it gives me a little bit more to support letting them go. Evidence in court. So let me give you a couple examples here, but the short of it is that application, what they tell you can become a real problem for them if they're puffing. So let's use the example of puffing first. So employees, it's human nature. If the job says, you know, we need A, B, C, D, E, F, G, and they can only do A, B, C, D, but they did a little bit of E, F, and G at one point. If they puff on that in their application, and later, you know, when I said that later they're going to be not terminated, but separated. And they say, well, wait a minute, I didn't know I was going to have to do F and G. Well, wait a minute, look at your application. You said you could do F and G. You said you could do payroll, that you've done it before. And now you're saying we're firing you because you did a poor job at payroll. Well, right, it was laid out. So look at those applications. And then another thing I tell you, another case I had on job applications was look at those resumes carefully. Look at them very carefully, because we had a case once, a senior college administrator. There was a gap in his resume. They didn't pick up on it when they hired him, but I saw a gap in his resume. Guess what? He had sued that employer for a form of discrimination, the same he was suing our clients. And if they had noticed that, you know, look at those dates. What happened during that? You want to ask in the interview, that probably could have been nipped in the bud. They probably would have found out. So look at those carefully. Briefly on Indeed and AI screening, we were talking about this before we started. I don't like handing off to a third party the screening process. I think that, you know, if you're a large company and doing AI screening, you think about it, all women could be screened by a computer, and then I've got a liability issue for you. So really, I'd be very careful about using any third party screening. Okay. Interviews. I'm sure you're all very experienced with this. I'll be brief. I talked about the pre-screening limitations. HR, managers, buddy approach, diverse interviewers. So in the interview process, I'd like to have a couple people in each room. One person's taking notes, both are. You got to train those managers on the notes they're taking. You don't want to have a note where it says, boy, Gary looks really old, right? You don't want them writing that down because then we have a legal problem. So train them. But getting different perspectives is really helpful. Stick to the essential functions of the job. Don't get, the job, their experience, the education is fine. Don't talk about wages. Don't talk about personal stuff. All these protected classes. It's human nature to say, oh, tell me about your family. Don't ask about the family, because that gets into issues with children, with, are you going to be able to, do you have to meet the bus every day? You don't want to have those kind of discussions. You focus on, can you do the job? The essential functions of the job. Hiring decisions, we find consensus is good for us. So if it's look back on 2 years later, who decided? Generally, the manager makes the decision. There could be consensus if there's a department. Get a couple of managers involved in the interview process. 5 minutes. Interview process. You want to be super careful that it's not just some old white guy who's deciding who they're going to pick. That can be problematic. Okay. Background checks. We could do a whole seminar on them. There's pros and cons. I'm just going to give you some practical advice. In my view, really think about it. Do you really need to do a background check? Do you want to know if they were terminated from the last job for stealing money? Sure, if they're handling money, or they're doing something that's financial in nature. Do you want to know if they are big supporters of Black Lives Matter? No, you don't want to. Don't go on Facebook to see that they're big supporters of Black Lives Matter. That creates a lot of problems for us if they later sue us for race discrimination, right? Do you want to know if they have a bad driving record? Not really, unless they're driving for you. You don't really need to know that. Do you want to know if they have criminal convictions from 5 years ago? Well, do you? It depends on the job, the sensitivity of the job. But I kind of lean on the side of, and again, you got to do it post-offer, but do you really need this? Do you want to do this? And what kind of liability could it create? Because once we know something, and that fact could be the basis for discrimination, you can't unring that bell. So think about it. Whether you need criminal, whether you need credit, and you can hire outside services to do this. But we look at it. It's sort of a balance of legal risk for a negligent hire. You hire an axe murderer, and then you didn't ask if he was an axe murderer. I guess negligent hiring. But on the other side of it is discrimination and how those inquiries can support a claim for discrimination. No Googling or social media. People do it all the time. People do it after I start the lawsuit defending, and then, hey, I Googled yesterday, and she's, what are you doing? Because then you become a fact witness, and then you find out information that has nothing to do with whether they can do the essential functions of the job. Screening references. I think you all know this. This is pretty basic. If you get a call and they want to reference name, rank, serial number, that's it. Dates that they worked for us and what the job was, say nothing more. Now, I know it's a valuable tool for HR to make a call to references, and you should do that. They might tell you something. And if they tell you something, that can help you on making a decision. Because again, this is, you're about to hire them. You haven't been married and bought a house together yet, right? So it's a better time to make the tough decision. Defamation interferes with contractual relations. That's what you could get sued for if you don't handle it right. The classic example is employee is separated. They're looking for another job, and then they call HR, and HR says something, and there's only 2 witnesses to that. It's not recorded, but they say something other than name, rank, and serial number. Well, guess what? The lawsuit, I sound like Joe Biden. Guess what? The lawsuit isn't just going to be about discrimination. There's going to be a separate count for you defamed me. You defamed me. I was just trying to get a new job, and you defamed me. So you want to avoid that. And when you make those calls to find out, just stick to job performance. Don't ask, well, what's the real story here or inquire. Just stick to job performance. Job offer. So this is the last thing I'm talking about. So offer letters, this is really boring stuff, but it becomes a huge problem. Don't write, here's an offer. Please sign below to accept the offer. That's a contract. We don't want contracts for our clients. They're employees at will. And even if on that letter you write, you're an employee at will, this is not a contract, employee at will, but you say, here's the offer, sign below if you accept, then a judge is going to say, well, I don't know if that's a contract or not. I guess we'll let the jury decide. And juries are made up of employees, not employers for the most part. So don't have a contract, no offer and acceptance, just provide the information. You're going to be starting on this date. This is going to be your salary, your wages, and here's the position. I like to attach the job description to that letter. So not only did you see it when you applied for the job, but you see it again on day one, or not day one yet, but with the letter that sets forth when you might start, and then you see that, and then they're stuck with that later. Final point is rejection letters, milk toast. Don't say, we interviewed many superior candidates, so we're not choosing you. Don't say anything. Just say, I'm sorry. Don't say I'm sorry, right? Just say,
Regrets?
no regrets.
No regrets.
Just say we won't be able to hire you. Just keep it non-committal. Don't do any kind of comparative thing with other people for obvious reasons. So I think that's it for me. And now, did you have a question? Go ahead. I know I said we're going to leave all the questions to the end, but I can't. You look somebody in the eye. You got to take the question. Yeah.
It was recently in the news, so I'm just curious, but I don't want to go down a rabbit hole. So let me know if you feel like that goes down a rabbit hole.
Yeah.
What is the legality around giving somebody an offer they haven't started, and then you go on a college campus and you protest in a very intense way, and then they revoke their offer? Is that legal? Because that has been going on, and I was just curious if you can do that, or you can let somebody go because they have taken place in a political rally that your firm or your organization really doesn't agree with.
Okay, so the beauty of my job is nothing is black and white, it's gray, right? So first is, if you did what I just said, you haven't made an offer and acceptance, right? So if we got it framed right, they don't have a contract right to come work for us. But to your point, we've written them the letter and they are coming on November 1st, right? So what are we going to do? I don't think that I would terminate that person at that point. It would depend on what they're doing, but does that have anything to do with the essential functions of their job? Or is it just, I'm a Trumper and they're against Trump and they went and protested. I don't want them working for me. That's a problem. That's a problem. Because they could tie it in, the 20-minute call would be asking you all these questions. Are they over 40? Are they, are they African American or black or whatever? We would kind of weigh it. So it's not black or white, but it's definitely gray. And I'd be really careful in that situation to retract the offer. What do you think, Jeremy? I'll turn it over to you.
Yeah, I think that's probably right. And I think a lot of this is, the stuff that's happening on college campuses, I think is a little different because these are college age kids. And I know I didn't make the best decisions always in college. And it could be, they got caught up in something that they didn't know what it exactly was going to be. So, I think it is wise not to jump the gun on that sort of thing. But you're right, it is all over the press now, and it will be interesting to see how it plays out. And, we will get more guidance from the courts because I am sure there will be litigation on this, which is unfortunate, but fortunately, that's the reality we live in now. So it's a great question. And I think it's something to keep an eye on for sure. But that's partly why you don't want to Google someone.
Exactly.
Because then you won't learn that. And to some degree, ignorance is bliss.
And what if that employees working remotely, Jeremy, how would that?
That's a good question and a great transition. If you can pass me the clicker to my remote employee presentation.
There are more questions, so we'll do those.
Yep.
Save it for the end,
Yes.
yeah.
So just some quick statistics. Everybody knows pre-pandemic remote work wasn't that big. Only about 5% of employees worked from home pre-pandemic. By May 2020, 60% work from home. So that's quite a change. Fortune 500 companies saw a large growth during the pandemic in remote work. A lot of studies have said roughly a third of the jobs in the country can be done remotely. So that's another thing that has enabled us. There is new technology that's allowing us to do this wonderful presentation. And then the last bullet point is commercial real estate levels. So in October of 2023, vacancies in commercial real estate are 50% of what they were in February 2020. So a lot of people aren't going back to the office. So what legal issues do you need to consider when you have remote employees? Unfortunately, there are a lot. We don't have time to cover all of them today. I'll touch on just a few, but in the slides is my email. If you have questions on anything, please don't hesitate to reach out. I'd be happy to talk to you about this. And there are, unfortunately, little legal issues everywhere you turn with remote employees. So the first issue is wage and hour violations under the Fair Labor and Standards Act for remote employees. Why is it important? Well, even unintentional violations can result in steep penalties, liquidated damages, or audits and investigations by the government, which won't make you happy. And so when does this apply? It's particularly important for non-exempt employees who are generally overtime eligible, who must be paid a minimum wage. And they must be paid at least minimum wage for all hours worked and 1.5 times minimum rate for overtime hours, requiring tracking of all hours worked. So that's an important part of having remote employees. If they're not exempt, they need to track their hours. And so what can happen? Well, you could become liable to pay your employees for small off-the-clock tasks that can add up, such as responding to emails or calls outside regularly scheduled work days, which if you have an employee working in Australia, the time zones are much different. They could be then working outside their regularly scheduled day and end up running into overtime or doing tasks that you didn't need them to do essentially at that time. So you need to be aware of it. So one of the risks is if you have a remote employee who's in Los Angeles, the minimum wage in Los Angeles is a lot higher than the rest of the country, $16.90 an hour. And there is also more generous overtime. So you need to be aware of that. And one of the themes that you will hear throughout my presentation is know where your employees are located. With a kind of remote workforce, it's easy to move wherever you want. And some employees don't think that is necessarily a big deal, but it is for your business. So you want to have strong hours or strong policies regarding hours worked. So you know, in your handbook, you can say employees only perform work at scheduled times or for a certain limited number of hours each day. And you can require that they get supervisory approval before they do any work outside of those hours. Prohibit work off the clock. And the key takeaway here is employees must be paid for all hours worked, even if worked in violation of a work policy. So, for example, if I worked overtime without Gary's approval, he can discipline me under the employee handbook policy where I have to record all my hours or can't work without supervisory approval, but he would still have to pay me under the Fair Labor Standards Act. So that would make me happy, especially at my overtime rates. So
Can you go back to that face?
yes, it's a little emoji smiling, and that is the employee smiling because they're getting paid extra work, even as they're being disciplined for violating the work policy. So the other big issue for remote work that is very tricky is tax obligations. So if you have remote employees in different states, they may be subject to different tax obligations. And the big ones, tax withholding requirements, and those vary by state and even within some municipalities. And then you have to figure in Social Security contributions and other local taxes. And there are also issues of employers potentially needing to register in a jurisdiction where they just have one remote employee. And then they might even trigger the requirements for corporate taxes, which would become a big problem. So, for example, a Vermont employer with an employee working from home in New York or Massachusetts will likely have an income tax withholding obligation in New York or Massachusetts, even if the only connection is that single employee. And technically, most of the state laws are pretty narrow in the sense that if you have someone who's taking a vacation and working in Colorado, even if it's just for a week, there's technically a requirement that you withhold wages. It's not strictly enforced, but it's something to be aware of. Some states have reciprocal agreements, but it's something to keep an eye on. So what is the risk? Even if you have an employee working remotely in a state without the employer's knowledge, the employer may be required to retroactively correct the tax reporting for that employee. And instead of the employee being liable for that tax, it could become the responsibility of the employer. So some takeaways, well, before we get to that, there's still a little more risk, particularly with hybrid work. An employer must allocate wages earned by an employee between two jurisdictions based on the time spent in each state. So if you are a St. Johnsbury employer and you have an employee working from home a few days a week in Hanover, you have to be able to figure out when they're working from each jurisdiction and take that into account when you're doing payroll for withholding taxes. So again, the main takeaway, know where your remote workers are. By policy, require them to notify you before they move. Periodically check in on them. And as I mentioned, there's a risk here that states may hold the employer liable for that tax liability. And it's even more troublesome, and there are more legal issues if you have a remote employee who is working abroad. That opens a floodgate of legal issues that go well beyond this presentation.
Jeremy, can I ask you a question on all that?
Sure.
So can an employer in Vermont or in New Hampshire say, sorry, we want all our employees to be in Vermont because I can't deal with all these headaches. You know, I've got a small HR department. Is that okay?
That is okay. If you make that communication after already having employees be remote, you just want to remind the employees that under the ADA, they can request a reasonable accommodation if it is needed for a disability. But yes, you can require all your employees to work on site still. The pandemic did not change that. It just made it something that is easier to do technologically. And we have the tools now to do it, but it doesn't take away the employer's discretion to dictate where the job is actually performed. And that's something in the job description that you can include that's helpful. And so you always want to keep that in mind. Then quickly, I'll touch on OSHA issues for remote employees. It hasn't become a big issue quite yet, but I would not be surprised if in the coming future it becomes one. So OSHA creates a general duty for all employers, essentially to keep a safe work site for their employees, so they're not tripping over chairs and getting injured on the job. So OSHA requires employers to keep records of work-related injuries and illnesses. And when you're working remotely, whether an injury is work-related can be a little complicated. So if I'm working from home and Gary asked me to do some work, and while I'm doing that, I am doing laundry and I somehow managed to hurt myself doing that, which that would be something I would do. We need to figure out, was that work-related and do we need to report it? So to be work-related, it needs to occur while the employee is being paid to work, and it needs to be directly related to the performance of the employee's duties, which again is why the job description is so important. And right now, OSHA won't really inspect home offices. They are holding off on that, but again, that could change, which I don't know what emoji that is. It was supposed to be a little more worrisome, but you can read into that whatever you will. So for example, if Gary gives and delivers me a client file in a box to my apartment while working from home, and I cut my hand opening the box during work hours, my job description says I work 9 to 5. That's a work-related injury that must be reported, and one that workers' compensation will likely cover. Same scenario, but it was a box from Amazon for the delicious treats I order from abroad. That's not work-related, so you wouldn't have to report that. But now the same scenario, but the box is delivered and I open it at 11 p.m. after work hours. That's likely not going to be work-related because it's not during work hours, which is why, again, it's important to be in the job description. But if I worked 8-hour days without the 9 to 5 guidelines, it would likely be work-related and compensable. So why, again, all employers in Vermont must obtain workers' comp insurance for all employees, even remote workers, and remote workers in another state. Remote workers in another state implicates kind of another issue. Does your policy cover it? So you want to check in with your carriers to make sure that your workers' comp policies cover remote workers in other states. Might require additional fee, policy addendum, but you want to do that. So key takeaways: employers still have a duty to ensure the health and safety of remote workers. You can do that by sending them guidelines on how to have an ergonomic home office. You can give them checklists to make sure that they are looking for safety issues in their home office every now and again. And you want to implement policies that really ensure employees report all work-related injuries regularly and train them on proper reporting procedures. So some other miscellaneous issues I'll just briefly touch on. Employees in different states have different meal and rest break requirements. In Vermont, we don't have any requirement for a meal or rest break. I would recommend one. They're helpful. But Massachusetts, you have to be given a 30-minute meal break after 6 hours. In New Hampshire, that's 30-minute meal break after 5 hours. Then there are also sick leave and other leave laws that are different in each jurisdiction and even within different jurisdictions and cities within jurisdictions. And then there are also employee privacy issues, which I'll get into. So then here are some quick tips on if you are bringing employees back to the office. Understandably, they may be a little reluctant. You want to communicate clearly the rationale behind why you're doing that. You want to do that so you get some buy-in. You want to implement a return to work policy where you're inviting workers back and also letting them know that if they need to work remotely, that's still an option that's on the table as an accommodation under the ADA. And so the other thing is food is also a great tool to bring employees back in the office and kind of raise morale. So just quickly moving into workplace privacy issues. What methods do employers use to monitor employees? Well, unfortunately, technological growth means there are tons and tons of ways to do this. You can monitor a computer screen, you can monitor the video and watch the employee, you can read their emails, you can log their keystrokes. There are all sorts of things that you can do. Whether or not you should do them is another question, but the tools are out there and they're surprisingly common. And fortunately, I think this isn't a lot of Vermont companies, but 45% of companies engage in actions to track the content that employees are accessing and keystrokes on a keyboard that employees are doing from either remotely or in the office. And 43% of companies indicated they reviewed and reviewed stored computer files of their employees. So it is becoming more and more prevalent. These statistics are from 2007. The technology's gotten better, so it's more prevalent. And one example is a company in, I believe it was Minnesota, asked employees if they wanted a microchip installed in their hand so that they could open doors and pay for things at the company cafeteria by waving their hand, which sounds cool and futuristic, but it is a little much for me. Surprisingly, 50 out of 80 employees volunteered to do that. We don't recommend it. at this time. So some of the legal issues with employee privacy, fortunately, right now, there aren't too many laws that are implicated here. You have the Electronic Communications Privacy Act, which includes two separate acts, which is a little confusing. The first one is the Wiretap Act, which protects communications in transit. It really doesn't apply because you're not, spies that are intercepting communications in the tubes that make up the internet, so to speak. And if the employer owns the email or communication system, the employees may have given consent to have those communications intercepted. So then the second is the Stored Communications Act, which is more applicable. It protects stored private communications held in electronic storage by third parties when accessed by someone either without authorization or exceeding authorization. It's limited in its ability to protect worker privacy. Courts have held that social media content that is readily accessible to the general public is exempt from protection. So if you're reading, someone's Facebook wall and you see that they're on campuses engaged in these protests while an employee, it wouldn't violate the Stored Communications Act to access that. But when that user has privacy settings on there and you create a fake account to get around privacy settings and friend them, that could implicate the Stored Communications Act.
And under Vermont law, you can't ask for their passwords.
Correct, yes. And so there's another exception, and it is it doesn't apply with respect to conduct authorized by the person or entity providing a wire or electronic communications service. What that means in English is if you in your handbook say employees, your email is not private, we have our email on our Outlook server, the act does not apply. So it, again, has limited ability to protect employees. There's also the Computer Fraud and Abuse Act that's very similar. I'm going to skip over that to save a little bit of time because it's a little intricate. But the key takeaway here is there's little federal law that's going to regulate how you monitor employees. So does Vermont create any limits? Not really. There's some, and most of it involves social media, as Gary just mentioned. You can't require an employee to turn over their social media account. You can't require an employee to access their account in the presence of the employer. You can't require an employee to change the privacy settings on their social media accounts. And there is a statute that prohibits employers from requiring or forcing employees or applicants to add anyone, including the employer, to his or her contacts associated with that social media account. So Vermont doesn't really do much either. But at this point, I would still be wary of doing this because the change is coming. It's already starting in other states like California and Connecticut. Most of the laws require the employer to give the employees notice when they're using these tools, which is reasonable. And some of them prevent employers from eavesdropping on phone calls or emails. And so, again, this is another remote employee issue, because if you have remote employees in a jurisdiction where there are privacy rules, you need to make sure you're complying with them. And then just a quick story about a cautious tale of a remote worker in the Netherlands who was working for an American company, and the American company required that employee to work on a video call for 9 hours without a break. Would American law regulate that? Debatably, but the EU law definitely does. And that American employer ran afoul of the law and ended up going bankrupt because the penalties that the EU assessed for, I believe it was a violation of the worker's dignity and also privacy, were so significant. So you really want to make sure you know where your employees are, especially if they're going to be abroad. So the key takeaways, if you have workers remote and you're going to implement some of these privacy tools or tools to monitor your employees, they're not currently regulated, but they will be. And so I think you should get out in front of it and try to notify employees that this is happening. Make sure you're only monitoring for legitimate purposes. And you want to know where your employees are so you can know what laws apply. And there are probably other less invasive ways to monitor your employees, and you should consider them. So again, key takeaway, know where your employees are located. It's very easy for them to move now. So again, we'll get to questions at the end, but I'll turn it over to Angelina.
Thank you.
And before you start, Angelina, just, you can get up anytime, use the restrooms, walk around. We're gonna keep rolling. We've got a lot of material to cover, but you're not gonna hurt our feelings if you walk out.
I'm Angelina, and I'll be talking about discipline and discharge today. It's a broad topic, so I'll try to go over lots of things, but if there is anything you have question on, do not hesitate to reach out, and we also have some time after for questions. So we're gonna go through those different subjects. Again, the idea here is to minimize your liability, and so we're gonna talk about tools that you can use to do so. So the first thing that we talked about already is policies, and you want to have a proactive discipline policy. And that will go, the tool that you have to do so, it's the handbook, the employee handbook. You want to make sure that you have a workplace misconduct policy in place and a discipline and disciplinary provision in there. Why? First off, because you're going to set the employer's expectations to the job, and you're also going to inform the employees of the consequences of not abiding by those policies. You want the handbook and you want the policy to be tailored to your business, and you want to make sure you want to make sure that it is, because that would be likely used as a shield during litigation if litigation arises. You need to carefully draft the policy because you want to avoid any language that could bind the employer. So avoid any words that could lead to reasonable reliance or promises. Make sure you also have an acknowledgement of receipt and review signed by the employee. You want to make sure that the employee received a copy of the handbook, that he understood the policy, and that he agrees to abide by the policy. Once you have this receipt, just keep it in the employee's file, whether it's electronic or paper. Tools that can be used in your policy, and would advise you to have them, is having a progressive discipline policy in place with disclaimers, of course, because you want to make sure and emphasize that the employer has discretions and doesn't have to follow all of the steps, but that can also show the employee that there are steps that you're going to follow. But again, disclaimer, you want to emphasize that the employer has discretion and doesn't have to go through all the steps before taking a corrective action. The policy can also include types of infractions. Again, you want to have a disclaimer in there that says, this is not an exhaustive list, because the one thing that you don't want to do with the policy is changing the at-will relationship of an employee and create any binding agreement. There are situations where during the course of a relationship with an employee, you're going to go through different handbooks and updates. And so the question arises that which handbook actually applies, which policy applies to that specific employee at the time you will actually want to take a corrective action. And so, Gary, do you want to talk about
that
this?
can get really complicated, but so say you have a 30-year employee and you've updated your manual, for every 5 years or something. And then there's a separation event, right, at the end of the 30 years. What manual applies? Like, let's say you have a progressive discipline in your earlier manual, and then you cut that out in the fourth version of it. And that fourth version is the one that applies when the person was terminated. Okay, but do they get the benefit of the earlier manual? It's kind of a morass. Generally, when you're looking at it to see which manual applies, you'd say, okay, if they're being terminated for, say, sexual harassment, and they had harassed somebody, over many, many decades, it's when the circumstance occurs, that's the manual that would generally apply. But it gets very complicated. So just keep in mind, if you, after 5 years, change your manual dramatically, there's going to be a tail of time when those older employees would have the benefit of the prior manual, at least in some degree, if we got into court fighting about it.
Thank you. And please, it's really important to train your supervisors and managers. I will not stress enough, and you're gonna hear me say that a couple of times today, and we'll say that again, because they are the one we're gonna be in contact with the employees, and you wanna make sure that they do not engage your liability by doing something they shouldn't have. So they must know the policy, and you should provide them with training, especially trainings in connection with harassment and discrimination and retaliation. Those are the three subjects that often give rise to litigation. So now that you have your policy in place, there are things you need to consider when you decide to take a corrective action against an employee or not. So first, is it in the best interest of the business to do so? When you're answering this question, also make sure that you are consistent. And so the best practices are, make sure you're consistent. If you have taken a corrective action against an employee for a specific behavior, it's going to be hard to argue why the same person, why another person doing the same conduct you're not taking any corrective action against that person. So again, be consistent, be prompt, especially have an internal investigation policy in your handbook. That's especially important for harassment claim, discrimination claim, retaliation claim, and also environment work claims. Make sure you involve HR all the time. Like, again, do not retaliate. So before any action is taken against an employee, make sure that that employee did not engage in a legally protected activity, because often we see that happen often when you don't know that the employee actually engaged in such activity and corrective action is taken against that employee. That would be likely a retaliation. Be specific, be discreet. Again, managers and supervisor has to be trained, and be honest and fair. Now, if your policy, you don't have you do not address a specific offense, it's not really a problem because most employees are at-will employees. But if you're thinking of what action should I be taken, again, be consistent, be reasonable. What action should you take in light under the circumstances based on that specific employee's behavior is history. You want to make sure that you size up the employees, look at what he has or she has done. You're going to be held by courts. You're going to be held liable based on your past conduct. So make sure, again, consistency is key. So now that we want to consider performance and how to mitigate and minimize your liability when you're conducting performance interviews and when you decide to actually take corrective action against an employee for performance issues. The first thing that you have to do, and it's really important, you need to document the disciplinary process. It's really important to have documents that are going to support the grounds for your decision. You want to obtain reviews in writing from all the employees, managers, and supervisors. You're kind of building your case. You want to give contemporaneous feedback, not periodic feedback. Whenever there is an issue, you need to address it now. We would advise you to consider performance improvement plans. They are helpful when you have employees who are engaged in the company and they just need some help to get better. It's better to keep those engaged employees than recruiting new employees, especially if it's slight performance issues. And that would promote the best interest of the business and also keep the other employees' morale up. So that's really beneficial for your business overall. Again, keep HR informed. You want to conduct in-person disciplinary meeting. During those meetings, give critical advice, dates, be direct. You want to allow the employee to respond to the critics. So often in your documents, you have a section with where the employees can actually disagree, agrees, make critics. It's also helpful to have a witness during that meeting. Take notes, write written summary, and have the employee sign the summary. And you should sign in as well and date it. You want to also, set particular goals. If you're working on improving the employee's performance, set goals. Discuss those goals with the employee and conduct a follow-up meeting with that employee. Because if you set goals and there's no follow-up, you're not going to be able to assess whether or not that employee has met those goals. And most importantly, you should be objective. Like Gary said earlier, we don't want overstatement. We don't want personal comments, any emotionally charged language. Do not be subjective. That will definitely, probably be used against you. So if you decide to discharge an employee, what is the good time to discharge an employee? We would say, if you're thinking of doing so, do not wait. But there is a big but. Please review your policies to make sure that before you take that action, which is this more severe adverse employment action you can take, you're aligned by your policy. And so again, you need to have HR involved, and supervisors and managers must be trained on the policies. Like we mentioned before, give a call to your counsel. When you have all the documents about that employee that justify the decision of separating from that employee, give a call to your counsel and have a discussion about the risks that are involved here if you decide to terminate that employee. And so your attorney will likely talk about, is the person from a protective class? That is important to know. Is the person being discharged a short amount of time after having lodged the complaint? That's going to be retaliation, and OSHA will, if it's a health violation, OSHA might get involved. You want to avoid all of those risks. Similarly, if it's an FMLA, if you're, for example, discharging that employee for absenteeism, make sure that employee did not get authorized leave under federal and Vermont laws. And again, there's also an ADA exposure here, and I'm going to turn it over to the ADA specialist here, if you want to talk a bit about the ADA exposure.
Yeah, and I want to say one thing about the Vermont Family Leave Act, this high burden on employers. So statutes, if you think about legal stuff in court, a civil case, you have to prove something by a preponderance of the evidence. That's getting over the 50-yard line on a football field. Our statute in Vermont, the employer, if you let somebody go for a legitimate reason, but you let them go while they're out on leave, family leave, we have to prove by what is clear and convincing evidence, right? Which is, you know, the 80-yard line, I guess, really hard. So if you're going to be calling us because somebody's out on FMLA and you want to let them go, guess what we're going to say? Don't do it. Don't do it. Because you're going to get stuck. But the doctor's note thing on the ADA, you've all done this dance, right? You got the employee, you know, they are not a good employee, but they know how to work the system, and they got the doctors. And then the appointment's going to be, it's not quite scheduled yet. And, you know, but my back is a mess and I just cannot come in, and, you know, and they're starting to give you doctor's notes. And the bottom line on that is, it's not what you think. It's not what they think. It's what the doctor says. So if you're getting doctor's notes and the doctor says, you know, they have to work remotely, you're stuck with that. And don't try to second guess the doctor. Because I mean, I had a case once. I was pretty young. I was like some of these folks. So I was just carrying the bags for my boss, but we got hit for punitive damages because the shop floor manager didn't want someone to come back. They had carpal tunnel, didn't want them to come back to work. They were worried about them. They thought they're going to hurt themselves. But the doctor's note said they can go back to work. So they second guessed the doctor. And then I had a CEO who's not very nice. So they hit us for punitive damages. So follow the medical.
And I just want to chime in and add that a lot of Vermont employers try to do the right thing and try to be helpful. But unfortunately, that's where you can run into trouble here, especially if you have a vague doctor's note, which is why it's helpful to have a really good, clear request for accommodation form where the doctor is required to give more than anxiety can't work, which isn't helpful.
Right. And even when you send the form, then they still write the one sentence letter and you're stuck with it, but it's good to give it to them, because some of them will fill it out. Right.
Yeah, sure. And the last thing again, in order to minimize the risk of litigation, just treat your departing employee with respect and dignity. I think sometimes we just forget that, but I truly believe that if you treat the employee with dignity and respect, you're minimizing the risk of litigation. So now that the decision is made, and so you're wondering, why should I put in that discipline or discharge letter? It would obviously depend on the specific situations, but general principle, you want to be clear, precise, and accurate. You don't want to put anything in there, like just Gary mentioned, that is not appropriate. The best practice is to set forth the central reason. Involve the managers, involve HR again. You want to align the letter with the personal file and any prior adverse employment actions. When you're drafting the letter, have the legal standard of discrimination and retaliation in mind to make sure that you draft the letter appropriately. And what I mean is, an employee is going to have to prove that the reason for termination is pretext. So if there's any language there that could help the employee prove that the reason for termination is a lie, that's going to be held against you. So you want to avoid that. In the end, it's still the employee's burden, but really, we have tools to minimize this. And like we've said before, exclude any harsh language, joke, emotional statements. And again, that letter is likely going to be used at trial or in a dispositive motion. So you want to have everything in your corner to succeed here. And I know I've been over a lot of things pretty fast to make sure that we don't keep you longer than noon. So if you have any question, again, do not hesitate. We'll have some time after for discussion, and you can also reach me and us by email. Thank you.
We're gonna quickly switch gears here and bring some new presenters up. So we're gonna turn off the video briefly, but we'll be back in 1 second.
All right, there we go, run. All right. Nice. Hey, thanks. All right, my name's John Wallace. Good morning. I'm a healthcare regulatory attorney, and my work in kind of regulatory issues often turns into employment law issues. So that's the perspective where I'm coming from. So I've been doing this work for 25 years, so slightly less. I have slightly less experience than the renowned Gary Carnegie. When I started, the president was Bill Clinton, who signed the first HIPAA legislation. So as the ADA defined Gary's early career, HIPAA defined my early career and everything that came after it. And you know, often HIPAA issues involve employment issues as well. And so what I'm going to talk about is exit interviews. I'm going to talk about separation meetings, and I'm also going to talk about things you should have on a separation checklist to make sure everybody knows what you're doing when an employee is leaving the organization. I think there's really 5 key benefits to doing, or actually, the reason I think exit interviews are important is because I've been involved in numerous instances where an employee has left the organization and no one asked them questions about what was going on. And they've involved situations where the organization has received a demand letter from an attorney who's representing a former employee. And the demand letter includes factual allegations that the organization was not familiar with, or maybe they had some familiarity with them, but they've never followed up on those issues. So you've got a request for compensation, but you have no idea what the factual basis for that request is. So it would have been nice to be able to talk to that employee before they left the organization, because the only other opportunity you're going to have to be able to talk to them now is in a deposition, and you'd like to avoid that. Another issue where exit interviews would have been helpful is when I've been asked to deal with a very significant issue with an organization, and in conducting an investigation to figure out kind of who made some really bad decisions, I start interviewing people and I find a department where everybody is new, and no one has any idea about the background of what were the decisions people were making and why. And then, you know, it would have been nice to have exit interviews for those people who left, but more importantly, maybe when the first or second person were leaving the same department, that would have been helpful to find out why those people are leaving. Perhaps there was a toxic manager that was effectively chasing people out of the organization, but was at the same time was making really bad decisions that contributed to this big expensive problem that I'm dealing with now. So if you think about, you know, the 20 minutes Gary talked about on a phone call, how about a 20-minute conversation with someone who is leaving the organization and you don't really know why? That's why I've always impressed upon people the importance of exit interviews. I think there's really 5 key benefits to doing exit interviews. The first one may be surprising coming from a lawyer because it has nothing to do with risk management or a legal issue. It's about employee engagement. You know, for exit interviews, you can identify people or situations that are compromising an individual's engagement in where they work. If you work with an organization where employee engagement is a priority, you know, or that organization knows that that is probably one of the biggest indicators of whether that organization is going to be successful, because they have a workforce that's showing up every day with their head on a swivel, looking to make a contribution every minute of every day. And if you work with an organization like that, you can tell. Everything is so much easier because everybody wants to help out. And so if that organization is focused on engagement, they're probably focused on their employee engagement survey. And if you're talking about things that are happening today that are compromising people's engagement, causing people to leave the organization, those issues may not show up in an employee engagement survey for a year or 2, or maybe never. Where they'll show up is at an exit interview, where a person is motivated to tell you what's really going on in the organization and why they're leaving. So I think that's really the most important reason for doing a exit interview. The second one is identify instances of retaliation where people are leaving because of the way they were treated, where they were treated. It may be because they have a perception that, you know, they've raised concerns, and because of that, they're being treated, you know, unfavorably after that. They may not even recognize what they've experienced is retaliation, but that's why it's important to have a sophisticated exit interview process so you can identify, so what's been happening to that person that is causing them to leave? Because as Angelina mentioned, you know, they could have been engaging in a protected activity by raising a concern around a legal compliance issue, and they may not even have known it. But it's important to know that now before they leave. Talk to a friend knows a lawyer, and they say, you know what, you've got a claim, and they didn't even know. Identify instances of constructive discharge, where the employee could claim that the working conditions were so intolerable that a reasonable person would have felt compelled to resign. So particularly in the harassment or discrimination space, constructive discharge is a legal issue where an employee can claim that although they technically left the organization voluntarily, the discrimination or harassment they were subject to was so intolerable that they had no choice. They were effectively discharged against their will. And the court will treat them that way and will pay damages, will award damages as though it were a wrongful and discriminatory discharge. But obviously you'd like to talk to that person on their way out the door, because that'll give you an opportunity to obviously address those concerns if it really is intolerable, or at least investigate and prepare for a defense. And it's the last chance. It's the last chance for discovering misconduct or obtaining candid feedback for someone who may be motivated to share. And you can identify complaints while you still have a chance to respond. Ideally, you're not doing an exit interview on the day the person's leaving. Ideally, you're doing it a day or two before, so you can, gather the initial information from them, say, God, that's concerning. We need to follow up on these. And maybe before they leave, we can say, thank you for sharing this information with us. This is what we've done since to address those issues. We'd like you to stay, but it's still your choice.
John, what about the grain of salt, the disgruntled employee? I mean, how do you approach that kind of exit?
So, I would do it the same way. So you're capturing everything they have to say. But, you have to look at what the factual basis is of the allegations they're making. And so if they are a disgruntled employee and they are going to contact a lawyer, or go to the Attorney General's office, then you're prepared to respond to the factual, to the facts of the kind of disgruntled nature about them leaving.
So what they're saying is their subjective view of the circumstances of their employment. That doesn't make it fact.
That's what's so critical, because in most instances, the person is talking about their emotions. They're talking about how they feel. They feel badly. Those aren't facts. Those are just feelings. What your job is to do is to harness whatever facts they may have, if any, and figure out, so, were we really doing something wrong? And your job is to separate those emotions from what are your factual risks? Because, who's ever going to look at it next, whether it's a regulator or an attorney, they're going to be focused with dealing with the facts as opposed to that person's emotions. And lastly, probably the most important risk that I get concerned with is the Vermont and Federal False Claims Act. The False Claims Act applies to any entity that submits claims for payment to the state or federal government. It could be a government contractor, a subcontractor, a grant recipient, a subrecipient, or an organization that has received some type of COVID funding, like PPP loans or provider relief funds or FEMA funds. Whenever you submit information to the government that is the basis of receiving payment, you are now subject to the False Claims Act. And you may not know it, but the penalty structure associated with the False Claims Act is so draconian. It's the type of penalties that cause organizations to go out of business. It doesn't make sense, but that's the way the law works, because it's intended to really deter the potential for submitting false information to the government in relation to payment. Or if you found out you've made a mistake, it's really to encourage you to fix those mistakes and return that money, because the penalties for keeping money that doesn't belong to you are draconian. So just so you know, in 2020, and this is becoming increasingly common in Vermont for organizations that receive Medicaid payments. Over the last 2 years, there have been many instances where the Attorney General's office has gone after organizations with a demand letter in relation to alleged False Claims Act issues, demand letters that dramatically exceed the total assets of an organization, would obviously put them out of business. But that's the way the enforcement around the Medicaid has started to work in Vermont. In 2021, the U.S. Department of Justice recovered $5.6 billion from False Claims Act cases. More than 75% involved healthcare providers, although that's starting to shift over the last year as recoveries are coming more from recipients of COVID funding. Around 70% are initiated by whistleblowers, or as described in the False Claims Act, key TAM relators. So what does that mean? It's employees. Employees who have some knowledge that the organization, or they believe the organization has some improper payments, and they're failing to give that money back to the government. They've raised those concerns internally, but no one has done anything about that. And so because of that, they can still be an employee. They can file a suit on behalf of the federal government under the False Claims Act. And if the government recovers money based on that suit, that the key time relator can keep up to a third of whatever the government recovers. And so obviously there are a lot of plaintiffs' attorneys that are interested in doing that work and talking to employees that may be government contractors, because that's really lucrative work to be involved with. So, you know, that's something that people need to understand, is that an employee could file a lawsuit under seal. So they may be litigating against you and you don't even know it, but they're, you know, using the information they gained as part of their employment to say, yeah, you've engaged in fraud against the government. So anytime a person makes an allegation of fraud or improper payments, it needs to be investigated and resolved because the risks are great. And then the retention of identified overpayments is, you know, where, you know, you submitted a claim for payment to the government, you thought it was accurate at the time, that employee says, you know what, when we submitted that information for the our FEMA claim, I realized that we've overstated some expenses. So then if that happens and that's true, you have 60 days to repay that money. If you don't, that becomes a false claim. And then that's when penalties can start to apply. I'm going to give you a scenario where an exit interview could have been helpful. So the facts are fictitious, but some of the statements are statements I've actually heard. This is Elaine employee. She's a 3-year employee. She's leaving for a new job because her coworkers exclude her from things. Her hours were reduced and no one will pick up shifts for her. So without an exit interview, you talk to Elaine's manager, Molly manager. And Molly says that, you know, it's really not regrettable turnover because Elaine is a complainer and she's not a team player. So could be the last you hear of Elaine. If you had done an exit interview with Elaine, you would have learned that she completed 2 event reports last year because her coworkers were not using personal protective equipment as they were required to. Elaine reported to Molly at the time that the coworkers told her, Elaine told her that the event report, Elaine reported to Molly that the coworkers told her that it's not her job to make them wear PPE, and if she had a problem with them, she needs to deal with them directly. So I've actually heard someone say that. And then Molly then told Elaine that the event reports were not appropriate and that she should have come to her because they handle their own issues. I've also heard that statement. Molly said that she would talk to staff, but Elaine has got to be part of the team. So, you know, what is the HR and compliance value of doing that exit interview with Elaine? Well, one, we identified a department that has a problematic culture and leadership. In the situation I was involved with, that person, Molly, is no longer in a leadership position. We identified a need to investigate and address retaliation. We identified an opportunity to update training on the code of conduct that strictly prohibits retaliation against employees who report problems. The training emphasizes that retaliation includes any conduct that would discourage someone from raising a similar concern in the future. That's what retaliation is. It's anything. Doesn't have to be someone losing their job, demoted. It doesn't have to come from a manager. It can be your coworkers. It can be kind of what people refer to as lateral violence. That's the same legal equivalent as retaliation. Now, those are the legal issues. The real benefit to having a process where you have effective exit interviews is you can support a culture that fosters an engaged workforce that supports the organization's goals, because that's the type of organization you want to work with. So your exit interviews, I would encourage you to have a policy that has a risk-based tailored exit interview process. So it should be a completion of an exit interview should be a condition for receiving a severance payment or a CTO or CTO payment. All exit employees should complete an exit form with HR staff So there's an opportunity for a conversation, but you don't need to interview everybody. I would have risk-based criteria for an interview with open-ended questions that occurs before the last day to allow for follow-up. So it would involve leaders or other individuals in sensitive positions like finance or IT. Individuals who have a history of raising complaints or concerns, or there's other potential warning signs. Like, when you talk to the manager, they're perseverating about raising concerns or things that have happened to them. They ask a lot of questions about events that have happened in the past. They seem to be gathering information on their way out the door. Those are warning signs that you may want to have a conversation with a person before they leave. So the things I would put in an exit interview outline is a series of questions that are intended to build rapport. What's their reason for leaving? Is there a new job? Are they going to get a pay increase? Are they relocating? And then start to ask them, so what's been going well? What do you like about the organization? And what could be improved? What's not going so well? And in relation to those opportunities for improvement, would you have been comfortable raising these concerns previously? Have you raised these concerns in the past? Has anyone done anything about that? Can you give me examples of when you or someone else has raised a concern? What's happened? Do you feel like your manager would have done something about it? And lastly, on the exit interview form that you would be having the person sign, there's always the question at the end, are you aware of any conduct or activities that violate the organization's policies or legal obligations, for example, not addressing improper payments, quality or safety concerns, discrimination or harassment. As Angelina said, if you're doing a summary of an interview, you want the employee to sign it. What I really don't appreciate is when someone in HR just has someone make a written statement. And so what you've got on that piece of paper is someone's feelings. They may look like facts, but they're usually not. But the way you've incorporated it to say, oh, it has some legitimacy, is you had them do it, you wrote it down, they signed it, and you accepted it. So those are allegations you've accepted without asking follow-up questions like, do you have firsthand knowledge of these things that you're describing, or are these just things you think or things you've heard about? That's why an interview is far more important than just having someone do a written statement. That's fine, go ahead. They don't have, so I'll go through this quickly. In relation to that, administrative leave meetings, when you're placing someone on administrative leave, I find these meetings are so important because employees are inevitably so confused because they're very stressed. So I think it's important to carefully structure your meeting with them when you're placing them on administrative leave, because people always cry. They don't even, you don't know why, they're just so nervous that that's what they do. Include a witness. It's not an interview. If they're a subject of investigation, you're going to choose the time and place of the interview. It's probably not then, unless this meeting is trying to give them, use the element of surprise to have them make an admission. But otherwise, you're probably going to want the subject to go last at the end of your investigation. Give them a clear message about their employment status. You're being placed on administrative leave pending completion of an internal investigation. Don't make the leave contingent on a third party, like resolution of a criminal charge or a report to APS. And, the issue is whether APS is going to investigate abuse or neglect. You never want to do that because you're not in control of timing. Those things can take years to resolve. You want to say, is this person safe to be at work? And that's something you should be able to address very quickly. Emphasize that the leave is routine under the circumstances. This is what we always do. I'm sorry, but we have to. And it's not disciplinary. And specify that the contact they may have with the organization or any employee, they can have no contact with the organization except specific HR staff. The HR staff will contact them, and this is the time frame when you'll hear from them. And then also suspend their email access and network access. So I think I'm out of time.
Grant you a few more moments.
Okay. Thank you. So lastly, in the separation meeting, if this is an involuntary separation, you always want to prepare a list of substantiated facts that are the cause of the termination. Focus on that. This is the cause. not everything, but this is what led to your departure. And use those to create the notice of termination letter. Choose a location that has a safe and easy exit, because sometimes things don't go that well. Do not discuss facts that are not the basis for the termination, like unsubstantiated facts, health issues, protected leave. Make sure you have a witness who's going to be a note taker. Make sure that person knows what their role is, what they should and shouldn't do. If the person raises a new allegation of wrongdoing, make sure you capture who, what, where, when, and whether it was reported to someone. If not, why not? But that's it. You know, it's not a prolonged conversation. It's probably the last you're going to talk to them unless there's a lawsuit. You want to gather information, but you don't want it to go on forever. And then you want to exit, just like I'm going to exit now. Thank you.
Thanks, John.
I would clap now, but nobody clapped.
Right, hi, everybody. My name's Hannah LaBelle. Thank you so much for being here today. I became an attorney right after Biden was inaugurated, so my perspective is a little newer than some of the others. So Madison and I are going to talk about some of the latest employment law changes in Vermont. I'm going to touch on 5 topics in pretty summary fashion, so don't hesitate to reach out to us if you have questions or if you want to learn more about it. So the first thing I want to talk about is updates to overtime salary regulations. So the United States Department of Labor has announced a proposal to increase the salary threshold under which employees are eligible for overtime pay from $35,568 to $55,068 by 2024. So that's like a 55% increase. This is sometimes referred to as the white collar exemption. So employees are subject to the overtime exemption if they're employed in a bona fide executive, administrative, or professional capacity. So to qualify for this exemption, 3 different tests have to be met. There's the salary basis test, the salary level test, and the duties test. The regulations governing overtime salary were last updated in 2019, so it's been a little while. So driving this kind of drastic 55% increase in salary threshold is the rapid growth in nominal wages that salaried employees have experienced over the past 4 years. And this is based on collected current wage data that the Department of Labor collects. According to the DOL, this rapid wage growth lessens the effectiveness of the current salary level threshold. So that's why they're making this change. The proposal is meant to ensure that the salary level effectively performs the historic function of screening non-exempt employees from the overtime exemption. The newly proposed rule is going to include automatic increases to the threshold every 3 years based on wage inflation using that same current wage data that has informed this increase. So there's going to be a notice that gets published in the Federal Register no fewer than 150 days before each automatic update with details of changes so that you'll be aware of it. You can make changes as needed. And if this proposal is absorbed, the main thing that you need to know is that these changes are probably an additional cost increase for businesses to absorb. The DOL estimates that in the first year, the proposed rule would actually impose about $1.2 billion of direct costs on employers. So with that knowledge, it may be helpful for you to review current payroll compliance practices, assess current workforce strategies to kind of determine whether it's feasible to raise the salaries of certain employees that are between those 2 thresholds so that they're above the new threshold, or maybe convert these employees to non-exempt status. In the first year, the Department of Labor is estimating that as many as 3.4 to 3.6 million workers who are currently exempt would become newly entitled to overtime protection. So that's something to think about as well. When the DOL promulgates the final rule, it is going to use the most recent wage data available. So that $55,068 threshold may not be accurate. It could be as high as $60,209, which is actually about a 70% increase from the current threshold. Something that might interest you is that the comment period for this is still open. This has not become effective yet. So businesses are encouraged to provide feedback about this before the November 7th deadline. So there is still time. If you're interested in learning more or providing feedback, you can do that. So the next thing I want to talk about is the Vermont Workers' Compensation Act. There's just a brief update of some things that have changed recently. So this was effective July 1st, 2023. The changes, as always, are intended to benefit individual Vermonters who are forced to leave work, due to a work-related injury. So Vermonters who are out of work and have family members who rely on their income will see their weekly dependent benefits increase from $10 per dependent to $20 per dependent. And so that applies to dependent children under 21 years of age. Additionally, low-income Vermonters who are receiving temporary partial disability are going to see increased benefits as well. And then injured workers who need expensive medical equipment like wheelchairs or hearing aids or things like that are now able to seek pre-authorization from their employer's insurance carriers for purchase of such equipment. The new law is also going to prohibit insurance carriers from imposing unreasonable work search requirements on injured workers who have been released to work by their healthcare providers but can't return to their prior employment. And as you may know, the Vermont Department of Labor reviews the state minimum wage each year. So just wanted to let you know what the new minimum wage is going to be effective January 1st of this upcoming 2024. So it's going to jump from $13.18 to $13.67, just a 49-cent increase. And also the minimum wage for tipped employees will change as well. If you're not familiar with that, the tipped minimum wage allows employers to pay a lower hourly rate as long as employees receive tips that are equal to or greater than the standard minimum wage. So that will go from $6.59 to $6.84. Next up are some new rules for nonprofits. I'm not sure how many of you here today will be impacted by this, but we just wanted to flag it for you. So Act 76, which became law on June 20th, 2023, now requires that all nonprofit organizations participate in providing unemployment insurance coverage for their employees, regardless of their size. This is different from the past, where organizations with fewer than 4 employees were exempt from needing to provide this type of coverage. So the new legislation will require that nonprofits report their wages quarterly, keep track of new hires, and be prepared to pay for any eligible unemployment claims that result from employee separations. So the nonprofits will have 2 choices when it comes to participating in this type of insurance. There are taxable entities. So those nonprofits that choose this option will have a 1% tax rate assigned to them as a new employer. They'll make quarterly contributions to the state based on their taxable payroll with an annual cap that's set by statute. The annual rate may fluctuate based on prior claims, taxable payroll, ranking among employers, a variety of other aspects. And they will also be subject to federal unemployment taxes, and any unemployment claims will be paid out of the state's unemployment insurance trust fund. The other alternative for these nonprofits are to choose the reimbursable employers function. So choosing this option, the nonprofits will not have to pay state or federal unemployment taxes, and they'll be exempt from quarterly state contributions. However, they must fully repay the state for any eligible unemployment claims that are paid related to individuals previously unemployed by their organization during the employee's base period of about 18 months prior to their claim. So whether taxable or reimbursable options the nonprofit chooses, the Vermont DOL notes that it's crucial to just continue to report quarterly wages to the state, because employers who fail to follow these requirements may end up being subject to interest and penalties, and we don't want that to happen to any of you. The change becomes effective July 1st, 2024, and the Vermont Department of Labor has been working with Common Good Vermont, and the 2 organizations intend to put on a kind of informational session sometime this coming November for the nonprofits who are going to be affected by this. So once we have the event details, we'd be more than happy to share that information with you should it be of interest. And the last thing I'm going to talk about are a few highlights from recent NLRB decisions. As you may know, the NLRB is an independent federal agency that's vested with the power to safeguard employees' rights to organize, engage with one another to seek better working conditions, choose whether or not to have a collective bargaining representative negotiate on their behalf, or refrain from doing so. The NLRB also acts to prevent and remedy unfair labor practices. It's a bifurcated agency, meaning one side is governed by a 5-person board and the other side by general counsel. Both the board members and the general counsel, importantly, are appointed by the president with consent of the Senate. So all but one of the current members of the NLRB board were either appointed or renominated by the Biden administration. So as you might imagine, the NLRB board was decidedly more red in appearance before January 2021. So this means that the decisions coming out of the NLRB recently are often, or not recently, but always, are highly politicized in nature. So that's kind of important to understand as you think about these. So two recent rulings have effectively prohibited employers from modifying employment terms such as pay, schedules, and benefits during any gaps between union contracts. So this overruled a 2017 decision that gave employers a lot of leeway to make unilateral changes affecting unionized employees. So the new ruling has also held that this past practice of unilateral changes, even if it was developed under a management's rights clause, could not authorize unilateral changes made after a collective bargaining agreement expires and while bargaining for a new agreement is underway. According to the NLRB chairwoman, actually, this decision better promotes the collective bargaining process that lies at the core of the NLRA. So in another late August decision, the NLRB made a ruling which requires that a union seeking to represent employees secure the right to do so through a secret ballot election. So this means now if a union says we have proof an uncoerced majority of a given employer's employees want to be union represented, the employer has to either voluntarily recognize the union or within 2 weeks file a petition for an election to be held. So this has shifted the burden of contesting union representation to the employer. And then finally, on August 26, 2023, the NLRB issued a direct final rule. So essentially that bypasses the usual notice and comment procedure that's followed with these decisions. And so this direct final rule amended a set of rules that were implemented in 2019, and the effect is to substantially shorten the period between the filing of a union election petition and the holding of an election. And this is being largely very well received by union workers who are seeing the decision as a return to the Obama era fair election rules, kind of further showing how politicized some of these decisions and rulings can be. So that's all from me. Thank you so much for your time, and reach out with any questions anytime. Thank you.
Okay, hi everyone, I'm Madison Procott, and as Hannah said, I'm also talking about Vermont updates, but I'm focusing specifically on Vermont's Fair Employment Practices Act. And so as of July 2023, several changes went into effect. So today I'm going to focus on what's changed and what hasn't, and as kind of a refresher and a heads up for what's going to happen. Okay, so first off, hiring equity. So as an employer cannot harass or discriminate based on a protected characteristic, and those protected characteristics in Vermont are race, color, religion, national origin, sex, sexual orientation, gender identity, ancestry, place of birth, age, crime victim status, or physical or mental condition. So an employer cannot harass or discriminate based on a protected characteristic. They cannot solicit employees based upon any of those characteristics, and cannot qualify or limit membership based on that. So you've always had an obligation to not retaliate against employees. So an employer cannot retaliate against persons who have participated in investigations by the state or agencies or departments into company practices. An employer cannot retaliate against persons lodging complaints about practices in violation of Act 80 or for supplying information that may indicate a violation. And so, as John said earlier, it's important to foster a workplace environment that does not tolerate retaliation, accept it, or endorse it. And that's so important because if an employee were to claim harassment or discrimination, the actions and comments of managers and coworkers can create liability for the company itself. Okay, next up, we see an expansion of the protected class definition with this new codification of Act 80. And so Act 80 already broadly defines a protected class, and it defines that protected class beyond what's federally recognized as a protected class. So this isn't to say either is not broad enough, both are pretty broad, but Focusing on Vermont specifically, Vermont includes ancestry, place of birth, crime victim status, and physical or mental conditions beyond what federal definition includes. And honing in on that last one, physical and mental conditions, Vermont's decision to use that language is intended to be more encompassing than the federal definition's use of disability. So it will likely capture more people within that, I guess, category. And so next up within this codification, we see an expansion of pay equity. And so an employer may still pay different wages. They just need to do so under very specific systems. And so you can pay differential wages to your employees based on a seniority system, a merit system, a system in which earnings are based on quantity or quality of production, or you can pay different wages based on a bona fide factor that is not a protected characteristic. And so if your company chooses to pay different wages based on that last category, that bona fide factor, if you were to face a harassment or discrimination suit, it's the employer's burden to prove that that difference in compensation is based not on a protected characteristic, but on something else. Also within this section, something that's important to remember is an employer cannot require that their employees don't discuss their compensation with others or outsiders. They have to be free to talk about what they're being paid. And it's sort of a internal back check to make sure that employees know what others are being paid and can make sure they're being paid fairly. Another addition, or I guess elimination from this new codification, is the elimination of "don't darken my door" provisions. So just to clarify, a "don't darken my door" provision is just a colloquial term for language in agreements that basically bars a person from further contact with another or another organization. And so within this new codification, in a settlement agreement for violation of this act, when harassment or discrimination has been alleged, an employer cannot prohibit, prevent, or restrict the employee from working for the employer or any parent company, subsidiary, division, or affiliate of the employee. And so this is so important in Vermont because so many of our companies have so much overlap. And if a settlement agreement were to bar an employee from working for that company, their affiliates again, it could mean that that employee will need to look outside the state to seek gainful employment. And so it makes sense they worked it into this section, but it is definitely something to be aware of if you are writing settlement agreements or engaging in settlement with your employees.
To chime in on that.
Yeah.
With a settlement agreement or severance, what we're trying to do is to make a peace and come back together and get a full release, right? So if you have some technicality in your settlement agreement that voids the whole thing. So here, sometimes they will just use the old form that Gary did 2 years ago on the last person. Make sure, in Vermont in particular, they're always updating laws and expanding employee rights, which is fine. But before you just use that old form, make sure you've got the new form.
So right, exactly. If you were to just reuse the old form post July of this year, if you did have language that required them not to work for this company again, it would be considered void and unenforceable. Okay, so last up for changes in this law, harassment and discrimination, we've seen changes in the standard and the definition. So within this new iteration, the language of the act eliminates the severe and pervasive standard. And so for a violation to occur, the harassment and discrimination plaintiff no longer needs to be severe or pervasive, which is a lower bar. So this new version of the act is also written in a way that uses harassment or discrimination interchangeably instead of as independent concepts, signaling that courts may treat the two as synonymous. And so these changes likely mean that the person alleging harassment or discrimination, their initial burden to bring a claim is lower than it was previously. So important to remember though, that there's still that caveat that behavior that a reasonable employee in the same protected class would consider to be a petty slight or trivial inconvenience shall not constitute an unlawful harassment or discrimination. So that caveat basically means it isn't a free-for-all. There's still some like back checking. So if another employee in that same protected class wouldn't consider it to be harassment or discrimination, the court also might not consider it to be harassment discrimination. So that's sort of a way to provide some bumpers on that, I guess. So I know this is a lot of information really quickly, but I'm happy to answer any questions you have going forward. And that's my time. So I'm going to pass it off to my colleague Ryan in Manchester.
And folks, it looks like we're gonna run over about 10 minutes or so. I'm sorry. You're not gonna hurt feelings if you have a bunch of things that need to go, but that's it. We don't want you to.
Oh,
Sorry. Brian, you can go ahead.
All right, hello everybody. My name is Ryan McClure, and I'm coming at you live from sunny Manchester, New Hampshire. So for those of you who aren't aware, our Manchester office is one of our 3 offices in New Hampshire, and we're located right downtown in the penthouse of City Hall Plaza. I know this has been a content-rich presentation. If anyone has any questions about the topics we've covered, please reach out. I'm going to round us out today with an update on developments in New Hampshire employment law. And Madison is going to drive my slideshow here as I'm remote, obviously. I'll discuss policy updates regarding marijuana as it pertains to reasonable accommodations, car accidents, and whether they are compensable under workers' comp, wage and hour law, handbooks, paid leave as an employee benefit, and 2 potential updates to be on the lookout for. So first up is marijuana. And so if we can go to the next slide, please, Madison. Okay, so So first up is marijuana. Thank you for bearing with us. Workplace advisors have long maintained that employers are not obligated to accommodate an employee's use of federally controlled substances such as marijuana. A recent New Hampshire Supreme Court case has held that an employer now has an obligation to accommodate the use of cannabis and potentially other controlled substances under certain circumstances. Many of you are likely aware of this case. It's admittedly from last year, but it's still worth discussing. In this case, the plaintiff suffered from PTSD. He was prescribed cannabis as a form of treatment. He requested as an accommodation to be exempted from the employer's drug testing policy, and the plaintiff brought suit after he was denied the requested accommodation. The takeaway here is that an employer may be required to exempt certain employees from drug testing as a reasonable accommodation under New Hampshire law. We've talked about accommodation request forms today. Accommodation requests should be considered carefully. These are factually specific analyses. They often require support. Be not afraid, however. We're here to help you navigate these situations. If you have any questions about disability accommodations, please call. Next slide, I have a workers' comp update for you. As you're all aware, injuries incurred while coming and going to work are not generally compensable under workers' comp because they didn't happen in the course of employment. So you're also aware, I'm sure, that there's an exception to this rule for special errands. So in the past, the special errand has been interpreted as a trip taken during the workday for work purposes. So for example, a bank run or a coffee run for the boss. The special errands exception applied only to these kinds of trips. So a recent New Hampshire Supreme Court case has expanded the scope of the special errand exception. to include, in some cases, an employee's drive home. So in this case at issue, the court stated that an employee's travel may be considered to be within the scope of employment if, buckle up, this is a mouthful, the trouble and time of making the journey or the special inconvenience, hazard, or urgency of making it in the particular circumstances is sufficiently substantial to be viewed as an integral part of the service itself. Did anybody get that? I didn't. In plain English, if we're sending an employee home for a business-related reason, injuries incurred during travel may now be compensable. In the case at issue, a true worker was in a motor vehicle accident after he was sent home in the middle of the day due to an impending storm. The court determined that his trip home was an integral part of his employment. In short, the decision was based on the fact that he was expected to return later that evening for storm cleanup. The takeaway here for the rest of us that are not tree companies is that certain scheduling practices and policies related to employees' comings and goings may need to be reconsidered and reviewed. If you have any questions about your scheduling practices or policies, please reach out. So moving right along, next slide, a wage and hour update for you. So the general rule, we all know, is that employees are to be paid overtime for hours worked over 40 in a work week, unless they are statutorily exempt and therefore a salaried employee. The administrative exemption currently applies where an employee makes a salary of at least $684 per week, performs office work directly related to the management or general business operations of the employer or the employer's customers, and whose primary duty includes the exercise of discretion and independent judgment with respect to matters of significance. So a good example of this is an office manager. So a recent federal case over here in the First Circuit, which includes New Hampshire, but not Vermont, has declined to apply the administrative exemption to dispatchers and controllers at a utility company. The issue here is that the employer failed to demonstrate that the dispatchers and controllers' primary duties consisted of work directly related to the management or general business operations. Employers should be reminded by this case that the Fair Labor Standards Act's exemptions technical difficulty, sorry about that. The Fair Labor Standards Act's exemptions are dependent upon a fact-intensive analysis. The functional realities of the job should be considered carefully, and job descriptions should be worded intentionally to accentuate the attributes of the job that will move the analysis under any claim that the employee was misclassified. So if you have any questions about employee classification, don't hesitate to reach out. As Jeremy mentioned earlier, these analyses under the Fair Labor Standards Act are heavily complicated by the realities of remote work. Further, Hannah told you about some of the updates that are coming to exemptions regarding minimum weekly salary requirements. Violations of the Fair Labor Standards Act can result in very unpleasant consequences. A 20-minute phone call to us could save you an immense amount of time and money. We're talking next about employee handbooks. So as Angelina discussed earlier, generally speaking, an employee handbook is not a legally binding contract unless it contains specific language. In New Hampshire, the rule is that an employer's policies and handbook only create a contract if they conform to the customary principles of contract formation. So offer, acceptance, consideration. Well, a recent New Hampshire federal case confirmed that where the plaintiff sued his employer claiming breach of contract based on the employer's alleged failure to abide by various policies in its employee manual, the employee's claims were dismissed, and the court affirmed the New Hampshire rule that policies in the employee manual and generally do not create an enforceable contract between the employee and the employer. So while this case is a win for the employer, It reminds us that if we are looking to enforce an obligation, it's best to put it in a contract, not a handbook policy. The big lesson here is that we want to review our handbooks to determine whether certain policies and disclaimers should be pulled out and provided special treatment in order to ensure that they're indeed interpreted as contracts and therefore enforceable. So, for example, non-solicitation agreements, non-compete agreements, and non-disclosure agreements. We want these to be enforceable, so we want to make sure that they're provided special treatment and not just stuck in our handbook. My last update for you is a positive note related to benefits. As we know, our state and federal medical leave acts provide for unpaid leave. Well, in New Hampshire, employers and employees have the option now to enroll in the nation's first voluntary paid family and medical leave plan through MetLife. Our New Hampshire law enthusiasts out there are likely all aware of this. It rolled out last summer. Now, I should say Vermont is rolling out a very similar paid family and medical leave program. It's currently only available to state employees, but it will be available this coming summer for Vermont employers with 10 or more employees, and the following summer, 2025, for employers with fewer than 10 employees. New Hampshire's plan, on the other hand, is up and running now for all employers. It offers up to 60% of an eligible employee's average weekly wage for up to 6 weeks per year for specified leaves of absence, including serious health conditions, caring for family members, parental bonding. So we encourage you to check out whether to enroll voluntarily in the plan. The plans are now active, so employees will likely be asking about it at some point. And so why is my attorney telling me about this? In addition to the obvious benefits to employee well-being, offering solid benefits is one of the most effective ways to keep employees happy and to keep them from wanting to sue you. So I'll conclude my bit here with 2 potential changes to watch for. First, a bill has been proposed in New Hampshire that's aimed at enhancing union protection. Currently, the law prohibits employers from requiring or pressuring employees not to join or attempt to join a union. That's the current law. The new bill would add to the current law by expanding an employer's prohibition on engaging in certain anti-union activities. Specifically, the proposed law would prohibit employers from requiring an employee to attend or participate in anti-union training of any kind, including requiring an employee to view a video that casts unions in a negative light. So notably, violations of this prohibition, as the law is proposed, would be subject to a fine of $10,000 per employee. The takeaway here, if our training or employment material consists of any anti-union material, we want to take a second look at these. They should comply with the current law, and we should be aware of whether this new law would require action. Finally, a recently proposed bill seeks to create a new category of employees that are protected from discrimination. This bill would guarantee employees the right to be vaccinated against COVID-19 and the right to use personal protective equipment such as face masks and face shields while working. This might seem unnecessary. You might ask, why would we need this? The bill is apparently a response to certain employers that precluded employees from wearing face masks while working in customer-facing roles during the pandemic. The takeaway here, when imposing policies related to face masks, we should keep this pending legislation in mind. However, we also need to consider current disability accommodation law. If we have an employee requesting an accommodation to not wear a face mask, they may be entitled to an accommodation for their health condition. If an employee insists against policy on wearing a mask, whether we have a duty to provide an accommodation should be considered in any case. Again, these are not enacted laws. They're only proposed laws to be aware of. So that's all I have for you. I'm Ryan McClure, and this has been your New Hampshire employment law update. If there are any questions, don't hesitate to call. I'm going to hand it back to you, Burlington.
Green.
You're sitting there and I don't want to get you. There we go. So I think we want to thank everybody for coming. I know there's an opportunity now to ask questions. I think some were sent out. There's also an opportunity to leave if you want to go, and try to begin. So don't forget to stay late for fine. But, we're gonna hang out and answer, questions.
Yeah, so if there are any in the room, certainly feel free. We have time, we're not in a rush, right? You guys are here. I mean, I'm gonna food for lunch, so, so we're happy to stay, and answer questions. I think, the first one that came through actually, was when you were speaking, Gary, was, providing some clarification about when you ask an employee to sign an offer letter, that you had mentioned that becomes more like a contract. So to kind of like explain that a little more, is that actually a contract?
So don't, I guess the first thing is, so don't do that. Don't have a line where they sign it. You're just sending them a letter to say, hey, you're starting on February 1, we're gonna pay you $53,000 a year. Your position is, bottle washing. And then we have benefits and stuff. That's it. I don't know if that answers your question exactly, but that's just memorializing a relationship, not a contractual relationship.
Yeah. That's great. There was a comment during your presentation, Angelina, just reiterating that the best advice ever is to document. Okay, like to kind of reiterate, yes, that is the best policy that you can do. Next up, we have a question, John, during your presentation, that asked, what about written resignation? So does having one help with constructive discharge claims? Should an employer ask for a letter of resignation whenever possible? So how does that go into that kind of separation and exit?
Yeah, that was on my exit checklist that if a person is resigning, you're gonna ask them to put that in writing.
And in your opinion, that is something that then helps if
Yes.
if we're to go
Yep.
to litigation. So great, good. Also during your presentation, there was a question, and I'll just ask it here. It looks like the person asking it heard it, but maybe just to reiterate for other people, if you place an employee on administrative leave, it's best practice to keep it paid. And I think you might have touched on that, or can you clarify?
Yes. I mean, because that raises the issue of, if you're not gonna pay someone, that's gonna look like it's disciplinary, where you haven't established the factual basis for that yet.
Great, fantastic. And there were a few questions in here about slides and presentation being available after the fact. And I do have everyone registered with the email address, so we'll reach out with information about that. There were a lot of questions about people requesting the information. That's always a good sign that you all provided some very nutritious information for everyone. So great job. That's all that came through, unless you have any others that are gonna come through, or yes, questions there. Fantastic, great.
So, I have a couple questions. The simple one, the language around attendance on the job description, how specific would that get?
It would depend on the job.
Okay.
And if it's, well, let's use HR, let's use HR employees as an example. We could all differ on this, but I think in my experience, you gotta be in the office, because you gotta be there for employees who things come up, they're upset about stuff, they think go to each other. If you're working remotely, it's a lot harder to be there and available. So in that instance, the job description of the HR professionals would have it in the office. But it depends on the job. I think I wouldn't across the board necessarily have attendance is required for this position, in the office. If it's not, I mean, if they can do it remotely some, we have kind of a loose policy, get your work done.
I would just add, if there are hours where you want the employees available, even if they are remote, that you specify them in the offer letter, and you want to be specific about that, but also retain discretion, change it. There's also a quirk in the Vermont law where twice a year, employees can request to work remotely, and employers have to consider it outside of a accommodation under the ADA. Doesn't mean they have to grant it, but it just means you need that in good faith review it, see if it's possible and whether or not you can do it.
But if it's a particular job where you really need them in the mornings or the afternoon, write it down.
Just as kind of an example of when this comes into play is if you have an employee who stops showing up.
Right.
If you have that job description that says you need to be here at 8 to 5 every day, you can say you've abandoned your job and that is grounds for separation.
Okay. You can't ask very,
Okay, sorry, and then we've got Scoop. I was wondering if you could just expand a little bit on Vermont's broader definition of protected classes and physical or mental condition, because I'd like, how would that be, you know, sort of defined, or how would, just a little bit more definition since it's not stating a disability. It seems much broader. Physical or mental condition.
It's much broader intentionally, and I think it's just meant, so that's gonna play out more in a court setting through case law rather than through like an actual explicit definition of those two. That's all we were offered, a physical or mental condition, and I think they were vague intentionally, and obviously this law is so new that we haven't seen a lot of case law. I guess like not, the whole law is not new, but some of the sections are new.
Right.
And so we haven't seen a lot of case law play out to give us a lot more specificity on that.
It's like what I described with the American disability, but the disability, that 30 years later, that it says.
Yeah.
But you're right, I think they wouldn't. Sorry, Karen.
No, I would just go ahead.
They wouldn't have changed, they wouldn't have gone to this definition unless they wanted to broaden.
And under the ADA, the definition is supposed to be as broad and as expansive as possible, but an example where this might come into play is I broke my arm earlier this summer. Is that a disability that's impacting my ability to do my job? No, but if, you know, I was terminated because I couldn't carry boxes, that might then be that definition.
Thank you.
Thanks for coming.
Thank you, guys.
We have to